Well, Bob, let's turn to the regulators' new guidance for human resource professionals. Is that unusual? I mean, isn't antitrust regulatory guidance typically addressed to antitrust professionals like you and your colleagues in the antitrust bar?
I think this is a special circumstance because DOJ in particular has said, we've gone after non-poaching agreements, we've gone after non-solicitation agreements over the past several years with high-tech industries, with Lucasfilm and Pixar and Google and Intel and the like. But the difference is they've now used the term criminal. And that has gotten everybody's attention that, okay, everything has been handled civilly. And I don't mean civilly in the pedestrian sense, but that a civil resolution to a particular matter in the form of injunctive relief. Now, there's a possibility, almost going back to the time at the beginning of the Sherman Act, when certain types of agreements regarding competitive relations would be dealt with criminally in the employment context, that they're saying, we've given you some period of time to become accustomed to non-poaching agreements as being highly problematic, to being the equivalent of price-fixing agreements, the equivalent of agreements to divide territories. I think the message is, HR professionals, you need to talk to your lawyers about this because this is really an important issue.
Well, I suppose I could try to read the guidance myself, Bob, but since you're here, why don't you explain it to me in plain English?
Well, they're talking about non-poaching agreements, non-solicitation agreements. If you have just a general agreement between two or more competitors that say, under no conditions are we going to agree, are we going to poach each other's employees, no matter what they are and who they are. We're not going to solicit each other. That, according to DOJ in particular, in the Antitrust Division, is highly problematic and potentially criminal. And they've demonstrated through their prior actions against a number of companies that this is something they will take very seriously. But they have ratcheted it up in a meaningful and significant way, as I mentioned before, by using the term, Becky, criminal. Because that means right now, under the antitrust laws, unlike when they were first adopted when it was a misdemeanor, under current antitrust law, it's up to 10 years in jail and up to a $100 million fine for corporations and up to $1 million fine for individuals. So there's very, very serious penalties on the criminal side as well as the civil side.